back when used to talk about all you Yankees coming down here referring to us. Man, we're not Yankees. We're from Birmingham. Anything north of Montgomery is a Yankee. But my family's Confederate through and through, from Alabama. And like I said, a lot of them were from this area, from Geneva County, actually Coffee Springs and Sampson. Tell you what I grew up my entire life knowing that I had Confederate ancestors. I was really blessed that my great-grandparents lived until I was 28 years old. They died the same year, as each other. And my great-grandmother died 3 months short of their 76th wedding anniversary. And so she actually knew most of my Confederate ancestors. They were her grandfathers and her uncles. So I knew all my life that I had Confederate ancestors because I'd talked to her about it. And like I said, they passed away when I was 28. And but it was really when I got into my 30s, I guess, that I started wanting to dig into it. Wanted to find out more about it. And I've been a history buff all my life. I'll tell y'all, I'm not one that goes out and studies battlefield and regimental tactics and strategies and uniforms. That's not my thing. My thing is in the causes of the war and why the Confederacy was right. And that's what I want to talk to you about tonight. I'm going to narrow it down to hopefully give you some information that you can use in combating some of the nonsense that the politically correct crowd among us likes to perpetuate. And two of the key issues is, that I'm going to speak about is secession. Was it legal? Is it American? And second of all, were our ancestors traitors? Did they commit treason against the United States of America by seceding from it? I'm convinced that of two things. That to make an educated vote in the modern political era, you have to know a little something about what occurred between 1861 and 1865. I'm also convinced that to understand what happened in that period of time, you also have to know a little bit about how this country was formed. And we are woefully miseducated as a country. So to start with that, what I'm going to do is I'm going to go back to the early days of the country and read to you some of the key elements, key areas of the Declaration of Independence. That was, incidentally, Virginia had actually declared its independence long before the other 12 colonies. They declared in May. But nonetheless, what was happened was that the Continental Congress formed and they voted as 13 colonies to write a formal Declaration of Independence for each one of them. And that holds, in my mind, the key of what separates America from every other country throughout the history of the world. It was written, of course, by a Southerner, by a Virginian named Thomas Jefferson. He was the principal writer. He took a lot of it from Richard Henry Lee, another Virginian. Took a lot of it from his ideas, but you can trace all of it back to the Lockean theory, which was John Locke, who in the 1600s wrote the first and second treaties on government. This was where natural law, or the idea of self-ownership, came into play. And listen to closely to what this paragraph. And I'm going to break this down for you, but here's the paragraph as a whole. The Declaration of Independence states, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. That was very heavily influenced by John Locke's writings. Natural law, natural rights. What are natural law? There's actually two concepts of this, and we need to know both, because one will convince some people and the other will convince other people. The secular definition of natural law is self-ownership, and it states that I am me, I'm a sovereign individual, I own myself. Therefore, you cannot inflict, damage to me or to my property. The religious definition states that I am created by God in His image. And just as He is perfectly free, I am also perfectly free in my relationship with Him. The Declaration of Independence was written on the basis of self-ownership, individual liberty. Of course, we see in one of the key sentences I'm going to point out that it was written from the religious definition. It states that they, meaning man, are endowed by their Creator with certain unalienable rights. So this tells us that the basis on which the country was originally formed is that, and when I say the country, I mean the 13 colonies in declaring their secession. It states that rights come from God. Rights cannot arbitrarily be taken away except by God. Man has no right to inflict his will against your will on you. That's the individual rights. And it goes on to say that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. This is an extremely important statement right here. I want to break this down for you. Let's take the first sentence. That to secure these rights, governments are instituted among men. Let's reverse that sentence. Governments are instituted to secure these rights. What rights? The right of individual self-ownership, of the right of pursuing your happiness, your life, liberty, pursuit of happiness, okay? But reverse that sentence. Instead of that to secure these rights, governments are instituted. Governments are instituted to secure these rights. It tells you the purpose of government. Thomas Jefferson said the only legitimate function of government is to protect the rights of individuals. The Declaration of Independence, the basis of U.S. law, says the exact same thing. And it goes on to say, deriving their just powers from the consent of the governed. If government derives its just powers from the consent of the governed, what has happened when government assumes powers that were not consented to? It has acted in a manner that is unjust. Would you agree? That's what it says, what the Declaration of Independence says. And it goes on that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it. We do not exist at the pleasure of government. Government exists to protect our rights, nothing more. Our rights are God-granted. They are not government-granted. And we have a right as self-owning individuals created in the likeness of God to govern our affairs however we see fit to most to best affect our own safety and happiness. That's the law of God. And when government becomes destructive of that, according to the basis of our law, the Declaration of Independence, when it becomes destructive of that end and it assumes powers that are unjust because we didn't consent to them, then we hold the unalienable right to dissolve our ties to that government. That's, again, it's all in the Declaration of Independence. That is the basis of how this country won its secession or separation from the English crown. This is an important part of the Declaration of Independence, but in reality, this is just the preamble. This is not the most important part. This is opening up the door, setting the mindset to what's about to happen. It's sort of the preamble. The second portion of the Declaration of Independence states how the English crown has violated these principles. And I'm not going to go through that. You all know what they are. Talked about the writs of assistance and stationing soldiers in people's homes and unfair taxation, things of that. So it was those acts that violated these principles. The meat of the Declaration is found in the last paragraph. And this is the real intent of the Declaration of Independence. And it says, "We therefore, the representatives of the United, small case U, States with a capital S, of America, in General Congress assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, do in the name and by the authority of the good people of these colonies, solemnly publish and declare that these united colonies are and of right ought to be free and independent states." So they were colonies prior to 1776, and they sought statehood. The Declaration of Independence is codified into U.S. law. It is law, and it is a document of separation. It is a secession document. It is the principle upon which our Constitution was founded. The Constitution is essentially a document that assigns power to government, but it restricts them from or the Bill of Rights more specifically, from infringing on the rights in the same manner as the English Crown. But going back to the document of secession, the Declaration of Independence, it says we are united colonies, or we are colonies, but we declare ourselves as free and independent states. What is the difference in a colony and a state? When I define words from that era, I find it important because words change meaning over time. In the 19th century, the term gay meant something entirely different than it does today. So you see what I'm talking about. Colony and state meant something a lot different today as well. Today we've come to see the state of Alabama as the province of the United States, as some greater collective form of government. That is not what the founders of this country formed. Colony in the 1828 Webster's Dictionary was defined as such: a company or body of people transplanted from their mother country to a remote province or country to cultivate and inhabit it, and remaining subject to the jurisdiction of the parent state. So we were subject to the jurisdiction of the English Crown prior to 1776. As a colony, as 13 colonies, we wanted to get away from that and restation ourselves as 13 states. A state, the 1828 Webster's Dictionary, is defined thusly: a political body or body politic, the whole body of people united under one government, whatever may be the form of government. Sounds a lot like a country, doesn't it? So they were colonies subject to a parent country, and they wanted to be free and independent states or free and independent countries. So you had the country of Virginia, the country of Massachusetts. And incidentally, when the war, the American Revolution ended in 1783, it was ended by the Treaty of Paris. The Treaty of Paris was not signed between Great Britain and the United States. It was signed between Great Britain and Virginia and Massachusetts and Connecticut and South Carolina and North Carolina separately. And the English Crown recognized that by virtue of the fact that the colonists had won their war, they had indeed become 13 separate countries. It wasn't until 1787, for 11 years, they existed under that agreement. They were united under the Articles of Confederation, which they later also separated from. But what the Articles of Confederation was, it simply existed as a Congress. The historical meaning of the word Congress is a body of ambassadors. So you had these 13 separate states, and they sent ambassadors to a meeting to talk about, to discuss the things that they were concerned with under the Articles of Confederation, but they had no lawmaking ability, as Congress does today. And they existed in this relationship for 11 years. If the Congress under the Confederation Articles wanted to make law, they couldn't do it. They had to go back to their home state and say, well, this is what we talked about, but the home state had to ratify or agree to it. And we existed under that agreement until 1787. The original Constitution was brought forward. It was called the Virginia Plan. It was a Federalist document. The founders were not really keen on political parties, but it was sort of the national progression of things that led them to realize, hey, we have cultural and philosophical differences, and so you had the Jeffersonian view of things, which was became the Democratic Republican Party, not to be confused with either of the parties that exist today, because there's really no relation. And then you had the Federalist Party, which was typically New England blue bloods, although there were some Federalists in the southern states as well. And there was the Federalist side of things was somewhere between very nationalistic and almost monarchical. They didn't object necessarily to the English crown or to the monarchical system of government. They just objected to the fact that they weren't in control of it, that England was. So in 1787, the Federalist Party brought forward what was the Virginia Plan. It was a Federalist document that called for the formation of a strong central government, something that the Jeffersonians objected to. It called for a perpetual president. A perpetual president. Chew on that for a minute. Sounds a lot like a king, doesn't it? That's what it was. It called for executive or presidential veto authority over state laws. So here they had seceded from this perpetual king, this monarchy that was 3,000 miles away, and now the Federalist Party wants to form a new one and reverse the states back into colonies, subject to another parent central government. State governors were to be appointed under the Virginia Plan by the perpetual president. So we would not have even gotten to elect our own governors. This guy that's sitting up there with life tenure, this monarch, he was going to give us our state governors. This plan was flatly rejected and completely shredded to the extent that virtually nothing of it made it into the United States Constitution. Nobody agreed with this. And it's interesting to tell you what the Federalist Party, how they thought about, how well this was going to go over. The first two votes that they took was they voted to elect George Washington as to preside over the Congress because he was so well revered. He was a nationalist. Washington was a great man, but his political leanings were nationalistic, central type authority, type of figure, but he was extremely revered throughout the states. And so if he presided over it, nobody would dare to question the decisions that were made. So they elected him to preside, and the second vote they took were when they assembled in Congress were to close the doors and take no record of what was being discussed. They were going to come out and essentially foist this on the people, these men, and decide this for us. That was the Federalist Party's ambition. It didn't work out that way. Robert Yates, what would later become what was known as an anti-federalist from New York, kept very well-documented notes of everything that was discussed, and the Virginia Plan was thankfully flatly rejected. They formed instead the Constitution, and the Constitution is simply a compact among individual states. It is what binds us together. They created a general government. That document created the government that now exists, although the government that now exists does not necessarily feel bound to the Constitution. But that's what it created, a general government with expressly limited and delegated powers. If you have the mind to, I recommend going to Article 1, Section 8, and seeing the 18 things that we delegated to Congress the authority to do. There's only 18 of them. The 10th Amendment says if it's not there, they can't do it. But you'll find a lot of stuff they do today that's not there. That's a whole different discussion. So they laid out this document, but then the states insisted on a Bill of Rights. Without the Bill of Rights, not a single state would have ratified the Constitution. It required 3/4 of them to ratify, but not a single one would have voted it in place. Specifically, and by the way, in the Virginia debates on ratification, when they were kicking it around, each state had their own ratification debate. Patrick Henry questioned the use of the words "we the people" in the preamble to the Constitution. Now, why might he have done that? Because he didn't want to create the perception that this document and this forming this government was going to be ratified or adopted by a consolidated mass of American people. And so this went back and forth, and I read most of this debate, and this directly led to the 10th Amendment, because the proponents of the Constitution said, we're not saying a consolidated mass of people are going to adopt it. We're saying that they're going to adopt it as we, the people, of the citizens of the respective states. That's where the 10th Amendment came from. And Henry predicted correctly that if we created the perception in the minds of the people that we are a singular nation of people, it will lead to one region attempting to dominate another region of the country. And, again, this all led to the bill, or to the 10th Amendment, which was supposed to have been the First Amendment. It was the most important one. 5 states, with their ratification agreements, every one of them insisted on having a 10th Amendment. You know, and what the 10th Amendment states is, it says Congress shall, the powers delegated to Congress are not delegated to Congress, nor prohibited to the states by the Constitution, or reserved to the states respectively or the people. In other words, what the 10th Amendment says is you can only do what we've delegated in the Constitution. And that's another important word, delegated. Delegated means, it does not mean surrender. Delegated, when I delegate authority to you, that means I retain the ownership of that authority, and I have the right to recall that ownership if you begin to abuse that authority. So they delegated specific powers, but reserved all others undelegated to themselves, according to the 10th Amendment. 5 states of the 13, with their ratification agreements, offered suggestions as to how the amendment should read, and from this we have the 10th Amendment. So this is how the document was formed. It's a compact among states. The states are sovereign countries, having secured that status by virtue of the fact that they were victorious against the English crown, under who they were previously provinces or colonies. They lived and existed as sovereign states, which means countries, for 11 years. And they formed this document, the Constitution, to hold them together, and chiefly for the purpose of enacting foreign trade and common defense, and that was pretty much it. So, is secession legal? Again, go back to what the 10th Amendment says. It says, if the power is not delegated to Congress nor prohibited to the states, then the states reserve that authority. Nowhere, absolutely positively nowhere in the Constitution is the word secession, separation, or dissolution mentioned. So if it's not mentioned, and the 10th Amendment says if it's not mentioned, it's reserved to the states, what does that tell us? That tells us it is not forbidden. Secondly, 3 states, Virginia, New York, and Rhode Island, in approving their ratification, asserted their right to withdraw from the Union should it become abusive of the purposes for which it was being created by adoption of the Constitution. Virginia's ratification stated the following. It said, the people of Virginia declare and make known that the powers granted under the Constitution, being derived from the people of the United States, may be resumed by them whensoever the same shall be perverted to their injury or oppression, and that every power not granted thereby remains with them and at their will. This was accepted as a condition of Virginia's ratification. If you have 13 parties to an organization, and one of them says, okay, I will join your organization, but I will only join under this condition, and the organization accepts his condition, does that not make it general among the entire membership? That's how it was seen with the 13 states that adopted the Constitution as well. When we accepted these conditions on New York, Virginia, and Rhode Island, it made those conditions universal throughout every state that had ratified the Constitution at that time, and every state that would join the Constitution or join the Union in future generations. An act Act of Secession is the basis upon which the country came into being as they seceded from Great Britain. Without secession, you do not have these United States of America. It's not possible. We're still under the English crown. I saw, and some of you may have seen a couple months ago, back in January, when South Carolina was holding their secession ball to celebrate secession, the sesquicentennial of it. And our National Heritage Defense Chief, Tom Hyder, was on Hardball, or whatever the name of that show is, with Chris Matthews. And Chris Matthews, just, in his usual manner, well, Mr. Hyder, secession, this radical idea, is this really something that we ought to be celebrating? Guess what? We celebrate it every year on the 4th of July. It's one of the oldest American holidays in the country, but this idiot up there with his TV show doesn't know that. To further substantiate that secession is a right, Jefferson acknowledged, one of the founding fathers of this union, who penned the Declaration of Independence, noted in his first inaugural address it was right. In a letter to James Madison in 1816, later on, Jefferson reiterated his support of the right of secession by saying, if any state in the Union will declare that it prefers separation to a continuance in Union, I have no hesitation in saying, let us separate. The New England states threatened secession on at least 3 occasions. The election of Jefferson was one of them. The Louisiana Purchase was another, and the War of 1812 was yet another. I believe there were 2 more, and I can't recall off the top of my head exactly what they were.
Mexico and annexation.
That's right. Annexation of Texas was another one. And then we even have this opinion from another president who stated, any people anywhere being inclined and having the power have the right to rise up and shake off the existing government and form a new one that suits them better. This is a most valuable, a most sacred right, a right which we hope and believe is to liberate the free world. Who said it? Anybody know? Abraham Lincoln, 1848. To take it a step further and show you how the founders of the country viewed the relationship of the 13 sovereign states with the general government, you have one of the first acts of constitutional usurpation was when John Adams was president. We were on the verge of war, what they called the quasi-war with France at that time. It never broke out into actual armed conflict, but there was some fear that it would, some support for it too. And so the country's in a little bit of an uproar. We're a young country at this time. This is 1798. Adams passes a law, a set of laws called the Alien Enemies Act and the Sedition Act. The Alien Enemies Act essentially made it illegal to be French. If you were of French descent, you could be here, but French immigrants, he essentially wanted to leave the country. The Sedition Act outlawed, interestingly, let me back up for 1 second. By this point, John Adams and Thomas Jefferson are mortal enemies. They hate each other because of their different views of government. Some of y'all may have seen this show, Founding Brothers, by Joseph Ellis. If you have it, throw it out the window. It's a load of bunk. Joseph Ellis is one of the worst historians. The guy's Founding Brothers. To show you how close to brothers these were, in 1804, a meeting between 2 of them took place in a little field where Aaron Burr killed Alexander Hamilton. That doesn't sound too much like brotherly love to me. Adams and Jefferson were not very much more, in fond relationship with one another either. So Adams is president in 1798. We're on the verge of war, and Adams makes it illegal to criticize the president or his administration. In his administration, there was only one office that you could criticize without breaking the law. The office of vice president. Anybody want to venture a guess as to who the vice president was?
Jefferson.
Thomas Jefferson. So you could criticize Jefferson, but anybody else, you went to jail. There was a congressman, I believe, from Vermont, whose name I believe was Matthew Lyons. As some of y'all may recall, John Adams had a slight weight problem. And Matthew Lyons on the House floor referred to him as his rotundity. And he was arrested under the Secession Act for offending the president. He was jailed for several months. He finally got his comeuppance because Aaron Burr and Thomas Jefferson both defeated John Adams for in the next presidential election. And Aaron Burr and Jefferson tied. Adams was soundly defeated. Of all the founders, he was the only one who served only one term as president. He was not elected to a second term. But Burr and Jefferson tied, which sent the election to Congress. And from his jail cell, Matthew Lyons cast a tie-breaking vote, putting John Adams' mortal enemy, Thomas Jefferson, into office as the president. But in response to the Alien and Sedition Acts that were clear violations of the First Amendment, Madison and Jefferson penned what came to be known as the Virginia and Kentucky Resolutions. Now this goes back to their view of the state and its relationship to the general government created by the Constitution. James Madison, the acknowledged father of the Constitution, in the Virginia Resolution said the following. He said that this assembly doth explicitly and peremptorily declare that it views the powers of the federal government as resulting from the compact, the Constitution, to which the states are parties, as limited by the plain sense and intention of the instrument constituting the compact, as no further valid that they are authorized by the grants enumerated in that compact, and in the case of a deliberate, palpable, and dangerous exercise of other powers not granted by the said compact, the states who are parties thereto have the right and are in duty bound to interpose for arresting the progress of evil. What he is saying is when the federal government steps out of its constitutional authority, the states are duty bound to interpose, which means to come between that federal government and the people who the states are bound to protect, to interpose, to step between, to nullify federal law, or the most extreme act of interposition, which is separating from the government as we did in 1776. Thomas Jefferson's words in the Kentucky Resolution were even stronger. He says the following, that the several states composing the United States of America are not united on the principle of unlimited submission to their general government, but that by a compact under the style and title of the Constitution for the United States and of amendments thereto, they constituted a general government for special purposes, and delegated to that government certain definite powers, reserving each state to itself the residuary mass of right to their own self-government, and that whensoever the federal government assumes undelegated powers, its acts are unauthoritative, void, and of no force. The federal government can only do what the Constitution says it can do. The Bill of Rights tells it what it cannot do. And the 9th and 10th Amendments say specifically, if we left anything out of what you cannot do, guess what? You can't do that either. And if you do, according to our founding fathers, we have the right through our state legislatures and our state governments to interpose and cut those powers off in order to protect our citizens. So, was secession legal? Again, the Constitution does not forbid it. The founding fathers acknowledged that it was, and without the doctrine of secession, this country does not exist. We seceded twice. We seceded from Great Britain in 1776, and in 1787 we seceded from our own government by virtue of the fact that we dumped the Articles of Confederation and adopted a new relationship. Now, does it make any sense to anybody in this room that the men who thought so highly of God-given powers and the God-given right of self-government would then turn around and form a government for their posterity under which there was no legal escape? It's preposterous. It's a ridiculous argument. Were they traitors? Our Confederate ancestors. The 1828 Webster's Dictionary defines treason as such. In the United States, treason is confined to the actual levying of war against the United States or adhering to its enemies, or adhering to their enemies, or giving them aid and comfort. If it says confined to the levying of war against the United States, number one, can Cuba, Portugal, Brazil, Germany, England, any of these countries commit treason by conducting war against a state within the United States? No, because they're foreign. So this tells me that for it to be treason, it has to, the levying of war against the states has to come from within. It's an act of war if it comes from without. Within, it is an act of treason. The Constitution itself, well, I'll get to that in a second. The Constitution itself defines treason as such. Treason against the United States shall consist only in levying war against them. Now notice it doesn't say in levying war against it. Do you see the distinction? Levying war against them is plural. So if the state of Massachusetts takes up arms against the state of Georgia, that is treason. It's making war against that state. Them is plural. It refers to individual states, not a consolidated nation. This must refer to internal conflict because an outside adversary cannot commit treason. I would submit to you that it was the North who committed treason, that it was the North who violated the Constitution, that by defying the act of secession or separation, which the founders of this country, which natural law, the laws of God say are a God-given, God-ordained right, that they committed treason against the very principles upon which this country was founded. The Confederate soldier sought simply to repel an invasion, to protect his home, to protect their families and their lives from that foreign invasion. In so doing, they were also defending the original intent of the Constitution as it was founded. It was the North who waged war. It was the North who sought to amend this relationship, not through the proper constitutional channels of amendment, but through an act of war, through force of arms. And what are the results of the South's defeat? I think that the answer is found in the correspondence between an English philosopher named Lord John Dahlberg Acton and Robert E. Lee. Lord Acton wrote in 1866 to Robert E. Lee, "I saw in states' rights the only availing check upon the absolutism of the sovereign will, and secession filled me with hope, not as the destruction, but as the redemption of democracy. Therefore I deemed that you were fighting the battles of our liberty, our progress, and our civilization. And I mourn for the state which was lost at Richmond more deeply than I rejoice over that which was saved at Waterloo." The United States, as the founders formed it, was a unique experience. The relation of the states and conferring upon the general government strict limited powers, and the government deriving its powers from the people of those states, was the reversal of every other form of government that existed until that time. Everything else coming from despotism or totalitarianism or some other form of dictatorship, essentially, where government tells you what your rights are. That's what Lord Acton is saying when he says, I deem that in states' rights you were fighting the battles of our liberty, meaning England's and the rest of the world, our progress and our civilization. And he goes on again to say, and I mourn for the state lost at Richmond more deeply than I rejoiced over what was saved at Waterloo. Robert E. Lee responded, and I believe his words prove prophetic. He said, "The consolidation of the states into one vast republic, sure to be aggressive abroad and despotic at home, will be the certain precursor of that ruin which has overwhelmed all those that have preceded it." Look around you today. Think about the destruction that has been done to our law, to our Constitution. Every gripe that you have with Washington, D.C. hinges on that destruction. The South was right. The South fought to preserve the Constitution, to preserve individual liberty, God-ordained rights, and the concept of limited government. Government given to the lawmakers by the people, not that is received by us from God and only God. There is no question in my mind the South was right. And as Jefferson Davis said, and this, understand where I'm coming from on this. Davis said, the principles for which we contended are bound to reassert themselves, although it may be in another time and in another form. It's natural. And that's my presentation.